Thank you.
Yes, we have a lot of information to give you. Mr. Futterman is going to speak to us about life insurance trusts and planning tax consequences, planning for trusts, what trustees should and shouldn't do as planning techniques that we all need to be aware of from an elder law perspective as well as a tax perspective. And Henry Montag is going to speak to us about various topics involving life insurance, particularly today. People must know about issues with a product called Universal Life. We have events that occur with our clients that are not good with respect to these policies. And I can personally vouch for Henry. I had a client with a situation, paid for a policy for many years, big premiums, and all of a sudden the policy was going to be null and void and not provide coverage. And Henry jumped in with a lot of expert information. Really have to try and catch these policies as soon as possible. In my experience, and I'm sure many would agree, our clients don't even know the type of life insurance that they have. So this is something that will be a great help in your practice as well today. So I'd like you to welcome our presenters and thank you once again. Just one more quick reminder, if you have questions, gentlemen, you want questions at the end or during the program? Henry?
I don't know if it makes a difference.
I think Aaron and I would enjoy being more interactive, and Aaron and I are going to do our job, try to be more interactive, so we encourage you to do the same.
We would just ask that you step up to the mic because we are being webcast today. So if you have questions, please do go to the mic with your questions. Enjoy, and let's welcome our presenters, folks. Thank you.
Thank you. Thank you.
Thanks.
All right. Well, first, I want to first thank Henry for asking me to do this with him. Henry, I've known Henry a long time, and he is an invaluable resource. And I encourage people to seek out his assistance and help when these issues come up. When it comes to these policies, quite frankly, they're overwhelming. And trying to parse through them and to have a trained eye like Henry help you out is invaluable sometimes. It really, it'll spare you a migraine headache. I know he's prevented a lot of aggravation for me over the course of time.
Thanks.
You're very welcome, Henry.
Thanks for that. And I'd like to thank Allison, I'd like to thank Eileen, and obviously I'd like to thank Aaron for inviting and for joining me. What Eileen said is so right on in terms of the fact that there's so many advisors that aren't aware of some of the problems that I'm going to be discussing. And if the advisors aren't aware, then certainly your clients aren't aware. And if your clients aren't aware, then certainly the individual who's responsible for the life insurance, whether it's individually owned or whether it's held in a trust, are certainly not aware. And the consequences are not, oh, shucks, I made a mistake. The consequences are the loss of the life insurance legacy that has been promised and that has been arranged by your client. So without further ado, let me just take you through some interesting facts in the area of life insurance, something called combination insurance, and the subject of long-term care insurance, and the interaction between everything. I've been doing this since 1976. This month is my 40th anniversary in the insurance industry, and that's a long time. I say so myself. Okay, so there are three types of policies. There's something called whole life insurance, which is guaranteed. There's something called, on the bottom, term insurance, which is guaranteed. And in the middle is what we're going to be speaking about today, the subject of flexible premium or universal life or indeterminate or adjustable or variable. They're all basically the same thing. And the significant factor here is that they are not guaranteed. So, back in the 1970s, 1980s, interest rates, if you recall, were in the vicinity of 5, 6, 7%. Back in 1980 to 1983, if you recall what happened, interest rates shot up to a high of 21%. Individuals that had money sitting in life insurance cash values that were being paid 3% said, I can keep my money here and earn 3%, or I can move it to the bank and earn 18 or 19%, I think I'll move my money from the insurance industry, from the insurance contract over to the bank. And what else closed more deals for the banks than even the higher interest rates? The toaster, the free toaster that they gave out. You still have yours, and most people do, and they still work. But the fact of the matter is that people were concentrating on whether they were getting 15%, 16%, 17%, whether they were getting a General Electric toaster or a Westinghouse toaster. Whatever the case is, they weren't concentrating on the fact that the insurance was not guaranteed. Because in 1982, 1983, E.F. Hutton said, we've got to do something about this outflow of money from the insurance industry over to the banks. So it took E.F. Hutton to create a life insurance division. And in 1983, E.F. Hutton created the first non-guaranteed universal life insurance contract, which was really nothing more than mixing some term insurance and some investments. The only difference was term insurance, as you may be aware, usually ends at age 80, in some cases age 82, whereas universal was able to extend until age 85, 87, 89, 90. Many people in my industry used age 95 as a good round age to be able to have a life insurance contract last until. Okay? So the bottom line is that when interest rates rise, people are able to either spend less money or they're able to extend their life insurance in dealing with universal life insurance. On the other hand, when interest rates decrease, then the premiums, although you're going to get the same bill from the insurance company, but the internal cost to pay for that premium to allow that contract to last until age 90 or 95 is going to increase. And therein lies the problem. And I'll get to that in just a moment. Okay? So, a couple of facts about life insurance. 45% of life insurance purchased between 1983 and 2003, 45% was this universal life insurance. So this isn't an isolated case of there might be a problem. Pretty much 1 out of 2 policies that your clients or you yourself might own is of a universal non-guaranteed nature. Most people are not aware of that. Harris poll, 60-some-odd% of people believe that when they get the bill from the insurance company, that's it. You know, all bets are off. As long as they pay the bill in full and on time, that's it. Not true. 10% of policies that are held in a trust, and if you think back between 1980s and 2000s, if you think back, what was the marital deduction back then? What was the exemption? Very, very low. If you had a taxable estate of over $500,000, your insurance person or your accountant or attorney was suggesting that you own that insurance outside of your taxable estate. So let me take you through what happened. Okay? This is what the factors that were needed to be able to judge how much the cost of a insurance contract would be. We needed the age of the insured, we needed the health of the insured, naturally how much the insured wanted to purchase, and we asked, how long would you like that insurance to last? Oh, I'd like it to last for the rest of my life. Well, okay, but just keep in mind that the longer you have it last, the more it's going to cost. Oh, well, in that case, I'm probably not going to make it to 100. Let's go 90, 95. And lastly, what interest rate shall we assume? This was, again, when interest rates were significantly higher. Some people wanted to assume 12%, some people assumed 10%, some people assumed 15%. On average, in my industry, the majority of people settle on somewhere between 8 or 9% as a realistic figure. Obviously, that didn't occur. Let's just take a look. Individual back in 1987 wanted to purchase $1 million. The conversation went something like this. Mr. Smith, how much insurance would you like to buy? I'd like to buy $1 million. Okay, how long would you like it to last? As I just explained, 95 is probably a good age. And what interest rate shall we use? And we would settle on somewhere in the vicinity of 8 to 9%. Okay, so the premium for $1 million of insurance to last until age 95, and these are real numbers, by the way, was $14,000. Okay? Just keep that in mind for a moment. Now, to avoid the estate taxes, we need to put that into some sort of a trust or have somebody else own it. Who should we use? Well, again, let's use my son. Let's use my eldest daughter. Whatever the case is, it was kept out of the individual's estate, and someone with less knowledge, less information, was now put in a position of being responsible for that insurance. And again, there was no mention of a guaranteed time period. There was no mention of the fact that interest rates might change and that there should be a strategy to address that change. And certainly the trustee qualifications were never even considered. 29 years later, here's what actually happened. The 8.9% that was assumed did not materialize. On average, it was virtually half that, 4.4%. That current $14,000 now will expire next year. And in order to keep that policy in force until age 95, the cost would have increased from $14,000 up to $26,000. The current premium, if the insured would continue that $14,000, rather than now buying $1 million worth of coverage, would now purchase virtually half that, $450,000. Okay? Now, how long the insurance lasts is really a function of these four individuals. Now let's take a look at each one. The agent's role. How many think it's the agent's responsibility to keep on top of their client and advise him or her as to what the cost would be, or update the information, or do any of that administrative function? Anybody believe that it's the insurance agent's responsibility? Most people do. Unfortunately, it's not the case. Agent's responsibility is merely to distribute the contract and to just sell it and distribute it. That's it. Agent has no further responsibility. Well, how about the insurance company? Well, no, it's not the insurance company's responsibility either. It's the insurance company's responsibility merely to just deliver the annual statement, deliver the policy, and then annually deliver the bill and the annual statement. Okay. Why don't the agents step up? Well, one, they may no longer be in the business. Two, they may be embarrassed that they thought that the premium was going to be this, and they never really concentrated on what the guarantee meant or didn't mean. And nobody really wants to talk about insurance. Nobody really likes to talk about it. So it was just a natural tendency on everyone's part just to continue to ignore it. So here's the first line of defense, gone right out the window. Second line of defense is the attorney. And while the attorney is involved with the legalities, oftentimes what's not discussed is how one should specifically monitor the policy funding that ILIT, that irrevocable life insurance trust. The next person is the CPA's role. Aaron, maybe you can talk about the CPA's. I'm kidding.
I took off my green eye shade a long time ago. I got smart.
So again, the CPA's role, again, very important, and the CPA's role is to make sure that there's a need for that life insurance, is to make certain that there's enough cash flow to pay for that life insurance policy. And he or she will oftentimes prepare the actual trust returns or the gift tax returns. But usually, he or she is not involved in the performance evaluations or making certain that the premiums that are paid are adequate to be able to maintain that policy until age 95 or whatever the case, whatever the decision was. And certainly there's no mention of any sort of annual monitoring or any potential problem. Private trustee's role. This is what Aaron was speaking about before. He or she is unaware of the fiduciary liabilities that they carry with that role of being the trustee. And certainly they're unaware of the performance risk that they assume, and certainly they're unaware and they don't have the skills necessary to monitor, review, or adjust those premiums to avoid that problem. So the bottom line is that there's good news and bad news. The good news is that it's an honor to be named trustee. It's an opportunity to manage not just your family, but the entire family's future wealth or future insurance, life insurance legacy. It's a very nice thing. But the bad news is that they don't have the information, they don't have the skills, they don't have the knowledge, and they're often unaware that they've assumed 100% of the liability because, as we said, it's not the insurance agent's role or responsibility, it's not the insurance company's responsibility, it's squarely the trustee. And as we learned earlier, only 10% of trustees are of the institutional nature, and the other 90% are your clients' sons and daughters. So, as Aaron just mentioned, the attributes of using a trust are wonderful. Not only do they, and again, I'm speaking of from between 1980 and 2003. Today, we're sitting with a different set of situations. But back then, as we said, 45% of your clients' contracts are of this non-guaranteed nature. So we're speaking of a very sophisticated asset. Back then, it was used to exclude. Today, it could certainly be used to provide all sorts of management that parents might want for their children. But the life insurance policies are not self-managing, and they can and they do lapse. Okay, so what are some of the issues for the trustees? Well, oftentimes the policies, as we said, did not perform as they were originally anticipated. Oftentimes, the company's financial positions may have changed. The cost of insurance has changed. In your handouts, and I know a few people just came in late, I'll give you these handouts, but in those handouts that you have, there are 3 recent Wall Street Journal articles, and the last one talks about the fact that the life insurance industry has now decided, because they're able to, increase the cost of these COIs, increase the cost of insurance. And what that's done is it's exacerbated the problem of not only are people suffering because the interest rates went from 9, 10, 11% down to 3%, 2%, but many of those individuals are under the misimpression that those premiums are steady and that those premiums don't change. So the cost of insurance is just one of those things that the insurance industry recently stepped in, and approximately 8 or 9 of the major insurance companies have just decided to increase that internal cost of insurance. And as I said, what that's done is it's further exacerbated the problem. For the Wall Street Journal to have run 3 stories within the last 6 months about people's life insurance policies expiring prematurely, it's a significant problem, and it's getting worse. So again, the companies are constantly developing new products, which is something that I'll talk about when we speak about the linked products or the combination products. The institutional trustee, which is only accounts for 10% of the management, that's the various trusts, U.S. Trust, Bessemer Trust, I could just go on and on. They have a responsibility because the OCC, the Office of the Control of the Currency, maintains an annual compliance meeting with them. So they have to do the right thing. They have to raise that premium over the years to make sure that it's covered. They are the minority, 10%. The other 90%, as we said, are children who have less information, less knowledge than their parents. So why do 23% of trust-owned life insurance or individually owned life insurance policies expire prematurely? All the reasons that we just mentioned. Owners are unaware that there's a problem. Private trustees don't have the skills. No one is monitoring. And the interest rates have steadily declined over the last 25 years. And no one currently is advising the trustees as to what should be done or what needs to be done to prevent this problem. The policy lacks active management. Why, in my opinion? My opinion, it's simple. There used to be 2 types of contracts. There used to be a term contract that was guaranteed, and there used to be a whole life contract that was guaranteed, which meant that you could safely take those life insurance policies, put them in the bottom left-hand drawer, and forget about them because there was nothing that needed to be done up until, as we said, E.F. Hutton decided to create a new type of policy, and that took the life insurance industry from what I called a buy and hold asset to a buy and manage asset. Problem is, no one told the advisor, no one told the client, no one told their trustees that this is something that now has to be actively managed. Now, I just told you what my feeling is. Here's what a senior editor for the Wall Street Journal had to say, and I'm going to just take a second and just read this because it's important. So if you just take a moment, is there anyone that can't read that? I've written multiple stories over the past 5 years for the Wall Street Journal about the impact of low interest rates on universal life policies. The problem is exacerbated because many people underfunded their policies, often unaware of how important it was to keep them well funded. Of the many consumers I've interviewed, most don't understand how the policies actually work Many have long since lost contact with the sales agent. I get a lot of consumers' response to these stories as the problem is so recurring. And what's the insurance industry's posturing? Anybody sad at the home office of the insurance company when somebody says, what? My premium just went from $5,000 to $8,000? I'll show them. I'm going to cancel my policy. Is anybody sad at the home office? No, they're very, very happy because they've just taken individuals' premiums for the last 10, 15, 20 plus years, and they've now fallen down to the bottom line, and there's now no need to pay a death benefit. So the insurance industry is not necessarily on top of the situation or as much as they could be. And again, one of those Wall Street Journal articles does a very nice job of explaining the senior reporter's feelings about the insurance industry. Basically, it's just not their problem. Actually, it's, as we said, it's in the best interest of the insurer when that policy expires. So again, I'm now going to get into some of the legal aspects that I'm welcoming. You know, I love the idea that Aaron is here to be able to do a much better job of explaining what is meant by the, well, again, let me just let Aaron take it rather than take a corner in for him.
Sure, okay. And I think this is one of the most important points, and this is surrounding yourself, if the trustee should surround themselves with professionals that understand the legal aspects, and hopefully we're in a position to advise our clients how the trust works and what their duties are, and then to reach out to someone like Henry and to explain what's going on with this. What can I do? Is there something I should be looking at? Is there something I should be thinking about? Is there something that, you know, I haven't considered? Is this policy still a good policy? Should it be maybe, you know, exchanged for something different? What makes sense? These are things that need to be considered. So to perform his or her duties, the trustee, you know, and if you read the Prudent Investor Act, they must adopt a formal investment strategy and diversify the assets in there if necessary. Regularly, and this is a key one, regularly monitor performance. You can't let this policy lapse. I mean, you gotta be mindful of it and make appropriate changes where necessary to keep it in force. So, again, I'm gonna throw it back to Henry at this point, and then when I come back, I'll go over some of the kind of not so recent and then some recent cases involving how trustees got themselves into trouble by a whole host of different little
it's
issues.
funny. People with a stock and bond portfolio, they might call their broker once a week, once a day, once an hour.
Check their phone every few minutes.
Once a month, once a quarter, once a year. And that $50,000 or $100,000 portfolio is getting more attention, but yet their $250,000 or $500,000 or $1 million plus life insurance policy hasn't seen the light of day in 10 years. Okay.
You're exasperated. Right?
Yeah.
It is.
So what's the procedure? This is a procedure that I use in my practice. We just have various questions that, as Aaron just mentioned, we ask the trustee to think about those. We ask the grantor to think about those. We try to encourage a family meeting. There's no better way to meet that next generation than to prevent their future life insurance legacy from expiring, as opposed to meeting that next generation by having them ask the question, how could this be? How can my mom or dad's life insurance policy have expired? Weren't you guiding them? Weren't you advising them? Who's responsible for this? And again, in a few moments, we'll get into some trustee lawsuits, and you could just see the writing on the wall unless you have some sort of a process. And as Aaron mentioned, the U.P.LA, creating an investment policy statement, creating an insurance performance evaluation, creating a vehicle to make certain that there is an adequate funding statement issued to the client on an annual basis. This is stuff sometimes that the insurance company puts out, but I'll show you in a minute how and where that information might be found and where it's buried. Again, this is some of the stuff that Aaron went over, so I don't want to waste time by going over it. But it's all about the process. As long as you have a process that you follow as an attorney, as a CPA, you're going to stay out of trouble if you can show in your notes that you've at least covered, not necessarily held the client's hand, but at least covered it and mentioned it in your client notes. The risk of liability is very, very high. Somebody sues an attorney, whether they win or not, the reputation can be hurt, and certainly it's a significant waste of time, and it doesn't do anything for one's individual practice. Life insurance has to be treated as any other asset class. Okay, so we've gone over why the evaluation is necessary to avoid that 23% expiring prematurely. As Aaron said, there are substantial product innovations that I'll speak about in a few moments. There's something called a secondary market, where heretofore it used to just be that you could either turn the policy back to the insurance company and get the cash value, or you can just merely stop making premium payments. Well, as we'll find out in a few moments, there are other choices. But the bottom line is that underwriting changes have taken place. As we know, people are living longer, which means that while the mortality costs in some companies have risen, the fact that people are living longer, new policies today, the mortality tables went into effect, latest round of mortality tables went into effect 2010, just 5.5 years ago. People are living longer, cost of insurance has decreased. Now, how can that be? How can the existing policies the cost to charge less expensive while the existing policies are being increased? Well, they're being increased because they can. The new policies have to remain competitive. The old policies, they've already got you, and they can do what they want. The new policies, they have to be competitive, so costs have gone down. These are factors that have to be taken into consideration in terms of whether or not what you have is actually in the best interest of the client, and whether or not the client can perhaps improve their situation. All right, so I'm going to come back to this. This is Trustee Lawsuits. I'm going to come back to this because you just spent a little bit of time. Let me move on with some of the other insurance issues, and then we'll let Aaron come back and spend a little bit of time on some of these trustee lawsuits. He sent me the cases. I've researched an awful lot of cases, but some of the cases that Aaron found were just mind-boggling.
It's frightening, right? It is.
I'm just going to take 1 minute on something called Grill versus Lincoln National, because I just spoke about it a second ago. It used to be that if you had an insurance policy, you would either cash it in, get the cash value, and walk away, and your insurance contract is canceled, or it would be a term policy and it would expire, and that would be the end of it. Or it could be a whole life policy where you just say, that's it, I'm no longer paying the premiums, I'm done. Insurance industry is very happy, as we said, when somebody decides to go ahead and just give up their policy. Last year, the Grill family, with a $7 million policy, went back to their agent and their insurance company, and they said, we're having problems paying this X number of dollar premium. What can we do to reduce in some amount of the premium? Well, the insurance company, Lincoln National, and the agent sat down with the client, and after an hour, they decided that they would reduce that $7 million policy down to a $3.5 million policy, and they would now able to keep the premium as where it was prior to their meeting. They went ahead, they reduced it. A year later, Dad died, and the beneficiaries realized that they had given up $3.5 million. Went to an attorney. The attorney said, did anyone mention to you the possibility of a life settlement? Is everyone familiar with what a life settlement is? Okay. A life settlement means that you can take your insurance policy and sell it to a secondary market, just like you would your home or your car or any other personal belonging. Life settlements have been around for years. How come no one has heard about them? Because the insurance companies have $3.5 million and earn perhaps 25%. That $3.5 million was worth in the secondary market approximately $900,000. But no one mentioned that. October of this year, the case is being heard. I believe that that's going to change the life insurance industry because up until now, the insurance industries were successful in curtailing the agent. Keep in mind, there's a difference between an agent and a broker. An agent works for one company and is primarily responsible for selling the products of that one company. If you're an agent of that company. They can control you. If they tell you, if you mention the word life settlement, you'll be let go, that will prevent an agent from mentioning that to his or her clients. Whereas a broker is not tied into any one company and can really, in my opinion, do what's right for the client and not hear what Mother Insurance Company is telling them to do. That's a class action, Brill versus Lincoln National, so there won't be a settlement. It'll be very interesting later this October when the case is back on the calendar to see what happens. Let me just move on. I'll come back to that in a moment too. Let me just talk very simply about long-term care insurance. Long-term care insurance has gotten some horrible, horrible press over the last 6 months, rightfully so. People who have purchased long-term care insurance over the last few years, they've watched their premiums increase by 30, 40, 50, 60%. Why? Because they can. In my opinion, they're taking advantage of the fact that interest rates have gone down and they can now blame an awful lot of what's gone on those interest rates. And because of that, they can now rationalize and justify increasing the premium. Now, in addition to the interest rates having gone down, which as we know is where the insurance industry makes the majority of their money with their invested premiums, there have been some other factors as well. Some of those other factors is that they assumed incorrectly the premium. Long-term care insurance is only 24, 25 years old. The actuaries had nothing to go by. So they just said, well, we think that a 60-year-old should be paying this much. No rhyme, no reason. There was no basis for that comparison. We think that there's going to be a utilization of 6 to 7%. They had no information, nothing to base it on. We think that X number of people are going to drop these policies. Well, the utilization has been significantly higher, and unlike the 8 or 9% that they assumed people would drop the policies, less than 2% of the population that ever purchased a long-term care insurance contract has ever dropped a policy. These things are valuable. I have several hundred clients that have purchased long-term care insurance with me, and I have approximately 40 of those clients that are now on claim. They're very happy. When you collect a claim, it's not anything, again, you receive better care when you're receiving money from an insurance company instead of when you're taking out of your own back pocket. So long-term care, I'm just giving an introduction. It's suffered some tremendous negative press, but the contract itself, the concept itself, is a very, very significant concept and a very, very good concept. As a matter of fact, it's so good that the insurance industry 3 years ago began combining long-term care insurance with life insurance. Let me get to that in a moment.
Henry, can I just...
Please.
I know in my office, I've had at least a dozen families come in with, I think it was Genworth, they were hit with a 60% increase. Have you guys experienced that as well? I mean, it's incredible. They've been paying it for, some of them were 8, 9 years paying it, and all of a sudden they come, can they do this to us? And I say, well, listen, I think if they do it to everyone even-handedly, they can, do it to all of us, right? And that's what happened. So they're given some pretty limiting options to reduce in order to reduce the premium. The coverage just gets crunched. And, when you look at it with these people and explaining what their now limited options are, it's heartbreaking because they spent a lot of money for these things. They really did. And, obviously they're hoping they don't need it, but I know in my office, at least a dozen families came in with that Genworth policy, 60%. And when the first one came in, was shocking, right? I mean, incredible. I'm sorry, Henry.
No,
I just, I find it incredible.
It's the way it is. Also, just want to mention, in addition to the benefits of long-term care, there's also a 20% New York State tax credit, meaning if your premium, I'm making up a number, if your premium is $5,000, it's really $4,000 because you're getting a $1,000 credit, not deduction, an actual state credit against your New York State income taxes. Okay, so here's where I talk about the combination of life insurance and long-term care insurance. Long-term care insurance, as good as it is, only 8%, 9% of the population ever purchased it. Back in 2005, when the government, the insurance industry was discussing the 2006 Pension Protection Act, they pushed in there this provision that you can now, among other things, withdraw money tax-free from the death benefit of an insurance policy. That could be a universal policy, that could be a whole life policy, that could even be a term policy. Somebody can actually buy $1 million term policy today, and next month or next year, withdraw up to the $1 million of the death benefit tax-free to pay for long-term care insurance. They did that as an incentive and added into the 2006 Pension Protection Act, which became effective January 1st of 2010, and the insurance industry first began coming out with the product in 2012, the end of 2011. So these combination products have been around for the last 3 years. Really significant. Most people are unaware. I think when Aaron was earlier speaking about some of the new innovations in the insurance industry, this to me is one of the biggest innovations. You can now, as I say, previously you had a death benefit, The fact that you became ill, the fact that you had a chronic illness, that you had needs for long-term care expenses, irrelevant. Now, with one of these new post-2012 life insurance contracts, you can now withdraw the death benefit tax-free to pay for long-term care expenses. Phenomenal concept. Please, and if you don't mind, please come up to the mic.
Is that only available from a policy that you purchase now, or can you tie it up with a policy that you had prior?
If the policy was issued past 2012, it can be. But if you had one issued 2010, 2009, no, it cannot be.
Okay, thank you.
Let me give you an example of what some of these combination contracts might look like. 68-year-old male, preferred non-tobacco user. Okay. Starts out with a $100,000 premium. That $100,000 premium can turn into immediately $159,000 death benefit. But what you're really buying this for is not the death benefit, but you're really buying it for the long-term care benefit. You're able to increase your death benefit, your initial premium of $100,000 on up to almost 5 times to $497,000. A significant way to use assets that you're not planning on using. And I'm sure many clients are living tight, but there are many individuals out there that have money that is just going to be passed from one generation to the next, or that's going to be used in the event that I ever need some sort of long-term care. I'm going to use this annuity or this money to pay for it. Well, here's a better way of using that dollar. And there's nothing magical about the $100,000. This can be done with a $50,000, $25,000, or $500,000 contract. It's just a means of taking advantage of the leverage. Okay, so there are several sources to provide this type of analytic review. Please.
Hi, the question came to mind. I'm Jan Visconti. If you have one of these insurance policies that allow an early takeout of the death benefit, so I guess for Medicaid planning, that would make that an available asset. So if you put it in the trust, if you put it in an era of trust to try to protect it, can the trust take out the asset, or how does that work if you have it in the trust?
Some people are calling that a step transaction.
Yeah, that's what I thought.
And if there's an estate tax problem, I would not advise it. If there's a potential Medicaid issue, again, I would not advise it because you're adding an asset that can be looked at by Medicaid as an available asset.
So if someone buys a life insurance policy after 2012, does it automatically have this provision in it or not?
Great question. It's a little bit beyond the scope of this conversation, but what I do with my clients, I present that, and if there's a possibility that they may consider Medicaid, I ask the insurance company to turn off that provision.
Oh, can it be
And that
turned
can
off
be
at
done.
any time?
Yes.
Or-
If you initiate it, it's deemed to be there. So the time to turn it off is before it's issued, or as it's being issued.
And then the question becomes, is the act of turning it off
No.
within, right, the 5 years?
Well, if
Is
you-
that a trend, right? I mean,
Well, if you do it when you're
Right.
initially buying it, it doesn't matter.
That's right.
But if you're trying to do it later, then yeah, that's clearly a transfer.
Great question. And again, the answer is that if there's perhaps a Medicaid issue, you might consider turning that benefit off. Otherwise, it's deemed to be available under Section 2036.
Thank you.
Okay. Dealing with today's facts. What was good then is possibly not good today. It's got to be checked. Somebody today may or may no longer need life insurance. As Aaron mentioned earlier, with the estate taxes now up to $5,400,000, people who bought life insurance to pay for their estate taxes when their estate taxes were,
600,000.
I go back before that. Back in 1976, it was a $250,000 marital deduction with a $60,000 exemption. So yeah, there are times where you might want to take that life insurance that was going to be used for state tax purposes and use it to perhaps purchase a long-term care contract. And one of the provisions of the 2006 Pension Protection Act is that it now allows you to convert life insurance into a long-term care contract. Prior to 2006, which became effective 2010, which was available 2012, you were not allowed to make that transfer. Today, you can make that transfer. There are many provisions that I can't even begin talking about because time just doesn't permit. But there are those situations that when you sit down, you can find out an awful lot of information about a particular client's situation. And I just think that that's something that needs to be done. It's basically, as we say, making best use of what you have today and comparing what you have to what might be available. The remediation choices, this is important. You can either pay a higher premium, you can reduce the death benefit, you can obtain a new contract if you're able to qualify, or you can do the life settlement, which we discussed earlier. Or, as I just mentioned, you can convert a life insurance policy into a income stream to pay for long-term care insurance. And there's significant benefits to do that. You can take an annuity, convert it to a single premium immediate annuity, which provides an income, and that income would normally be partially taxable and partially non-taxable, considered a return of premium. But if you're using that annuity to pay for a long-term care contract, then 100% of that income stream is non-taxable. Again, it's a big thing that I'm just lightly going over, but that's a huge thing because there's a lot of clients out there sitting with annuities. And an annuity is a wonderful place to accumulate money, but it's the worst place to distribute money. Okay, just exploring other companies' contracts. There are various reasons. The possibility that will prevent you from doing that is poor health. Now, keep in mind, sometimes people say, well, gee, I had cancer 10 years ago. I'm probably not qualified. Somebody might say, well, yeah, but I have high blood pressure, or I had a coronary bypass. Underwriting today has become much different than it was in the early 80s or 90s. Back then, in the early 90s, you were either a standard, you were a smoker, or you were preferred. Today, there are several different premium classes. The insurance industry today is more interested in having somebody purchase an insurance contract, and they're making it easier. Modern pharmacology has taken various illnesses that have been there in the past, and they're all of a sudden saying, we're not afraid of diabetes. We're not afraid of somebody that had a heart attack. We're not afraid of somebody that may have had cancer more than 5 years ago. It pays to explore it. Discussed the life settlement options. Insurance company prohibits it. We discussed why. I'm going to go through a couple of quick examples, and then I'm going to turn the floor back over to Aaron. Case example 1. Individual was considered a smoker. He stopped smoking. I was able to take the existing policy, knock down his premium from $25,000 down to $19,000, simply by saying, excuse me, this gentleman gave up smoking 5-6 years ago, and he should now be eligible for a discount. $6,000 just for asking. Case example 2. Bill cases. Individual, male age 52, had several contracts totaling $1,175,000. They were universal policies. The guarantee on 2 of those policies were up until age 77. He was paying $10,600. He had $90,000 of cash value. By simply taking that $90,000 of cash value and doing what's known as a 1035 tax-free exchange, of moving that cash value from an old policy into a new policy, we were able to increase his death benefit from $1,175,000 to $1,875,000, maintaining the same premium and increasing the guarantee from age 77 to age 95. This was a gentleman who told me there's really nothing that can be done. Example 3 happened this year. It's a function of finding out what the client's objectives are. This client purchased a second to die policy, which means that the death benefit is not paid at the first death, it's paid at the second death. Therefore, it's significantly less expensive. But they were purchasing it for the benefit of their children and grandchildren. So they really weren't interested in the cash value. They were interested in maximizing the death benefit. It's paying $16,000 for a $1 million policy. Having found out what I found out, I did a little bit of shopping and found out that for $16,000 with another company, I was able to purchase a $2 million second to die life insurance contract.
I hope they gave you something for that. I mean, other than the premium, my goodness.
Real situation. This just happened earlier this year.
Holy.
Okay. Increased this premium, kept his premium constant, but increased the death benefit twofold. This seems complicated, and I don't want to make it complicated, but if you don't need money, you can take that annuity, in this situation, a $100,000 annuity for an individual male age 65, and convert it into a $317,000 death benefit immediately from day one. If you want to take the time to say, well, I could earn 5-6% in a taxable investment net of taxes, it would take that person 36 years to come up with what he or she could have purchased from day one by converting that policy into what's known as a single premium whole life. A single premium, $100,000, turns into approximately $317,000. Tax-free, by the way. Whereas that annuity or taxable mutual fund would have, of course, been taxable. I'm going to conclude with this. Individual, 2 years ago, 77, had a house, no longer interested in managing the house. 2 sons said, Dad, I think you should go ahead and just sell out the house and, put the money away and let's just move forward. The father listened to his 2 sons, and he went ahead, liquidated the $600,000 house, a little bit more net of broker's fees. He had $600,000. Put that $600,000 into the bank. He was earning 3%. After taxes, he was really earning 2%. So on $600,000, he was walking home with $12,000 net after taxes. I call this life insurance arbitrage. When you buy an annuity, you're betting you're going to live. When you buy a life insurance contract, you're betting you're going to die. But what happens when you put the 2 of them together? You get the best of both worlds. I took Part of that $600,000, approximately $285,000, and I bought a single premium immediate annuity. Not married, so we weren't concerned about any sort of ongoing income. But after Dad passed away, $285,000, that after taxes bought $26,000 of income. Previous, he was earning $12,000. He's now earning $26,000, more than double his income. Kids looked at me and they said, well, that's great, but, now we no longer have $600,000, double my dad's income, but now we no longer have $600,000. Now I only have $315,000 left. I took that $315,000 and that created a net income stream sufficient to pay for a $600,000 life insurance policy. So the net result was that we increased the dad's $12,000 annual income to $26,000, and we took the balance of $315,000 and purchased an annuity that threw off enough income to pay for a $600,000 policy, which incidentally was out of the taxable estate. And if you remember 2 years ago, New York State gift tax was significantly less than it is today. We avoided a gift tax situation by removing the $600,000 asset and more than double dad's income. These are just the types of situations that can be explored if you take the time to explore it. I just want to take a quick second. The case that I just put up behind me, I'm not going to mention the attorney's name, since he was a Long Island attorney, but the Schneider case was a situation where the attorney was involved in the estate planning, and there was $1 million policy which the attorney allowed to remain in the insured's taxable estate. This was, again, several years ago, before the 5.4 million. And the $1 million policy, since it was left in the taxable estate, had approximately $450,000 of taxes that were paid. Again, beneficiaries realized that after the dad passed away, that the attorney should have removed that $1 million policy and took him to court, and the court initially said, no standing, no case. They took it one step further, and they were basically given standing, and they were allowed, for the first time, for the trust beneficiaries to sue the grantor's attorney. The case was eventually settled, but that case shook up the American Bar Association to the point where myself and my co-author were asked to write a book on the subject, and the book is coming out, published by the ABA, coming out this fall, called The Advisor/Trustee's Guide to Managing Risk and Avoiding a Life Insurance Policy Crisis. So this is a real active situation. Compliments of, as I say, the American Bar Association to begin alerting and providing information to the attorneys to make certain that they don't wind up in a similar situation. I think we finished pretty much right on time. Eileen, are we good? All right. Again, we will both be here for any questions. Any closing points?
No, I just want to reiterate what a valuable resource Henry is to attorneys here, and I would encourage all of you to reach out and speak with this man. And by the way, another point, just as I guess part of our practice, I mean, I think we're doing our clients a disservice not to review these things routinely. And it's an opportunity to sit down with perhaps the extended family, which is, I guess I'm making the assumption that the children are the trustees, an opportunity to introduce yourself and make sure that they're on top of these things, because it is a thankless job, and there's a lot to consider, and it's a dangerous, it's a dangerous arena that we put these kids into, the parents, and it's an opportunity for us to advise them and do a good job for our clients. And I want to thank everyone for your attention, and I appreciate it. Thank you.